Hello everyone, I am Vijayalakshmi Dayanava here to explain specific performance of contracts. So, let us begin with understanding what is specific performance of contracts. Specific performance means fulfilling a promise made under a contract as agreed. Specific performance is equitable relief given by the court to enforce against the defendant the duty of doing what he agreed by the contract to do. A party to a contract who is aggrieved because the contract is breached by another party and another party has the option to file a suit for a specific performance compelling to perform his part of contract. In our country, most of the specific performance suits relate to sale of immovable properties. Section 9 of the Specific Relief Act provides that a person against whom a relief is claimed may be pled by the way of defense. He can plead by any ground which is available to him under any law relating to the contract. Following are the defenses available under law of contract. Incapacity of parties. Section under Contract Act 10, 11 and 12. Uncertainty of contract. 29 under Section 93 of the Evidence Act. Absence of concluded contract. Fraud. Section 14, 17 and 19. Misrepresentation under Section 14, 18 and 19. Mistake under Section 14, 20, 21 and 22. Illegality or want of authority to enter into contract. 23, 24, 26 and 28. Incapacity of parties. One of the conditions for a contract is that the payment should be made by the parties competent to contract as provided by Section 10 of the Indian Contract Act. Section 11 of the Act provides that a person who is major, of sound mind and not disqualified from contracting by any law to which he is a subject is a competent for entering into a contract. Therefore, it is clear that the person not fulfilling these three conditions would not be competent person to a contract. Such person would be termed as incapable of entering into a contract. Minority and disqualification from personal law are thus incapacities of a parties to enter into a contract. However, it is noted that a guardian on behalf of a minor can enter into a contract. Uncertainty of contract. Section 29 of the Contract Act, which is based on the principle of English law, enjoins that agreement the meaning of the which is not certain or capable of being made certain are void. There shall be specific description of a subject matter of which the contract is to be executed. Only the certainty would make the agreement valid. In other words, uncertainty of contract would make it a void contract. For example, an agreement requiring the landlord to make all the necessary repairs as and where desired is uncertain because the phrase necessary repairs is vague and there is nothing to indicate what kind of repairs were regarded by the parties as necessary. Absence of concluded contract. For enforcing a contract, it must be proved that it is a concluded contract. If a contract is not a concluded contract, then the defendant may make his defense that as the contract is not a concluded one, it is not specifically enforceable. Fraud. Under Section 14 of the Contract Act, there are certain conditions on which it will be determined whether the consent to the contract was free or not. For free consent, a contract should not be caused by the fraud as defined in Section 17 of the Contract Act. Fraud means and includes certain acts committed by parties to the contract with intent to deceive another party or to induce that party to enter into a contract. Such acts are enumerated and in Section 17 of a Contract Act. Misrepresentation. Another condition for free consent is that there shall be no misrepresentation as defined in Section 18 for the Contract Act. Consent given under misrepresentation of facts cannot amount to free consent, thereby making the contract void. A misrepresentation is a false statement of fact made by one party to another, which, whilst not being a term of contract, includes other party to enter the contract. Said definition of misrepresentation is inclusive in nature. Mistake. Mistake of law is provided under Section 21 of the Contract Act. It provides that a contract is not voidable because it was caused by a mistake as to any law force in India. Although a mistake of facts were in a contract. In order to render a contract void on the ground of mistakes, three things must exist: mistake of common and mutual, mistake of fact and not a law, mistakes of essential to the agreement. Illegality or want of authority to enter into a contract. Section 11 of the Contract Act speaks about the person have authority to enter into a contract. It is already discussed earlier. Section 20 of a Succession Act provides that no person shall by marriage acquire any interest in the property of a person whom he or she marries. For considering defences in such suits, both the Specific Relief Act and the Indian Contract Act are to be conjointly read and interpreted. Thank you.